All right, everyone be seated. Thank you. Ready to proceed?
Yes, Your Honor.
All right. All right.
State calls Janice Burke.
Good afternoon. All right, could you face our clerk, please, to be sworn?
The testimony you're about to provide.
You can please speak clearly into the microphone.
Good afternoon, ma'am.
Hi.
Would you please introduce yourself to the jury?
My name is Janice Burke, B-U-R-K-E.
And Ms. Burke, what do you do for a living?
I am a family law attorney.
How long have you been an attorney?
Since March of 1990, so next month, 29 years.
Do you know the victim in this case, Melissa Howard?
I do, yes.
How do you know her?
She was my client in 2004.
What type of representation did you provide for Ms. Howard?
She had gone through a divorce the year prior to, and I did not represent her in that. In that particular case, she and her former husband had a child together, Taylor, and pursuant to their final judgment they agreed to, he had primary custody of their son. And she came to see me in February of 2004, I think it was, she wanted to see about modifying the custody arrangement so that the child would be living primarily with her.
How would you describe the custody case that you were representing Ms. Howard for?
The contested one that I did,
Yes.
Is that what you're asking me about? It was, I think a lot of people would probably refer to it as ugly and nasty. It was not good.
Did you personally take any precautions during the pendency of that case?
We had several hearings before the final hearing to decide if custody should be modified. And at the conclusion of each of those hearings, I did ask for bailiff or law enforcement to escort me to my car, which is unusual for me.
What was the result of the custody case?
The result was that primary custody was going to be switched over to Melissa, from her former husband to Melissa.
Had that happened prior to her death? Meaning the
switch of custody?
Yes.
No, sir.
Okay. When was it set to occur?
January the 6th, 2006.
Now, as part of this process, did you prepare a proposed order for Judge Stone?
I did. We had, the hearing had gotten bifurcated, so we had two different hearings in 2005. And Judge Stone sent us a letter, basically, telling us that he was granting Melissa's request to switch custody and had asked me to prepare a proposed judgment. And so I did that in September of 2005, I believe it was. And her former husband's attorney, I submitted it to him and he objected to it. And ultimately, we ended up going back to see Judge Stone on November 29th, 2005. And so the order did not get signed.
So you custody changing?
Yes. The court announced in September that custody was to switch, and even said the weekend it was to switch, which was in September. And the former husband didn't comply with that. And so that's why we went back to court in November, because of their objections to the order, and also because Mr. Howard had not complied with turning the child over to the mom, to Melissa, in September.
The week that Melissa Howard was killed,
Yes.
did you have any contact with her?
Yes.
Right? Could you describe for the jury any phone calls received by your office?
On January the 3rd, she left a message. January 3rd, 2006.
Did you personally speak with her at that time?
No.
Was there a subsequent time that week that you did speak with her?
I called her on...
Approach. If you just wait for a moment. You need to approach. If you could re-ask that question, I think I interrupted the witness before she got an opportunity to fully answer that.
Yes,
If
Judge.
you could do that again, please.
Yes, Judge. Ma'am, I think where we were, correct me if I'm wrong, is I had asked if your office had received any calls from Melissa that week.
Yes,
And I believe your testimony was that she called on the 3rd, but that you did not speak with her. Is that correct?
I did not.
Okay.
She left a message. Oh, never mind. Yes.
Okay. So she left a message, but you didn't talk to her.
Correct.
Okay. Was there a subsequent time that week where you did speak with her on the phone?
Yes.
What day was that?
The evening of January the 4th.
How do you know it was evening? How do you remember?
Well, because it was dark, and I remember calling her after hours. I was in Defeniak Springs, either at my in-laws or my mother's. I can't remember which place, because my in-laws and my mom all live in Defeniak. And I needed to call her
What was the reason for you calling her?
because she had called the day prior.
Had you returned her call prior to
I had
that?
not returned her call, and I knew that the 6th was coming up as far as switching custody. So I needed to talk to her.
What phone number did you call to reach Miss Howard?
I would have called her home number. It's 682-0644.
Okay.
There's no cell service at my mom's or my in-laws. I know that doesn't affect her end, but for some reason, I called her home number.
All right. Were you able to reach Melissa Howard when you called her on the evening of January 4th, 2006?
I did, yes.
Before we get into content of the conversation, could you describe for me how did she sound when she answered the phone?
She was crying when she answered the phone.
How would you characterize her demeanor?
In that conversation,
Yes, ma'am.
she was crying, she was upset. I was attempting to get her to tell me what was going on. She was not hysterical, so I could understand her. But you know how you get the feeling someone's headed that way? I just got the impression that she was about to not be able to talk. She was that upset when I called her.
Did you have to admonish her any way in the way that she was speaking to make sure that you could understand her?
I told her to slow down. I just told her to slow down and tell me what was going on. I was just calling to check on her, to let her know that everything was good for that Friday. And I did not expect, when she answered the phone, for her to be upset.
What would you describe her emotional state to be at that moment?
Describe it or what she told me?
Just describe it.
Um,
How would you describe her emotions at that moment?
I'll hear this answer, then we'll approach. It's a well-taken objection. I'll hear this answer, and then we'll deal with this further.
well, the crying wasn't from pain. The crying was because she was so upset over something. So I wanted to find out what it was.
Okay, we're gonna
Thank you, ma'am.
We're going to stop there. Let's take the jury out at this time. Ray, we're going to have a seat. Mr. Drake, I think what you're going to seek to introduce is information from this witness in the form of information provided by Ms. Howard during this telephone call. Is that right?
Yes, Your Honor.
And the defense has interjected, and I think in a very timely manner, an objection. This is hearsay.
Yes, Judge.
And what I think the court has done is given you the opportunity to lay a foundation for an exception to the hearsay rule. Is that right?
Yes, Your Honor.
Do you believe at this time that's been laid?
I do, Judge.
All right. Tell me why that is.
There's a hearsay exception for an excited utterance. Basically, when someone is under the stress or excitement of a startling event, and it is related to that particular startling event, that is an exception to the hearsay rule. The availability of that declarant is immaterial. It does not matter if she's living, dead, here, or otherwise. The key is that she has not had an opportunity to engage in reflective thought, and that while still under that stress and excitement, she is relaying what is going on. Ms. Burke has testified that Ms. Howard was talking quickly, she was crying, she was upset. She did not expect Melissa Howard to be talking like that at all when she called her. She testified that the crying was not because she was in pain. The crying is relating to the event. The law does not...
And if I recall, I stopped further testimony. The jury's been taken out before the content
Yes.
of what Ms. Howard said was stated, correct?
Correct.
All right, go ahead.
The case law does not require that the startling event and the statement be close in time, but that is one factor, and it's present in this case. So there are actually situations where something like this could come in a day later, 2 days later. But in this case, we know it was Wednesday evening, January 4th. There's been testimony that that was the same day that Russell Holbrook was present at the house. So we know from the facts in this case what that startling event was, and you're going to hear her testimony about how that was described in the words of Melissa Howard.
Or there are other objections out of others.
I want to hear that. I want to hear all of your objections, but do the excited utterance portion of your objection first.
Don't have the benefit, didn't realize we were going to be sitting here doing it. But the way I remember side of others is it has to be unplanned reaction, startling event. It has to be spontaneous. It can't be, I called my attorney, she called me back.
If I were to suggest to you that the law is very clear that it has to be an excited utterance that relates to the startling or event or condition while the declarant was under the stress of that startling event or condition. Would anyone disagree that one of the keys is there's no time for reflection or thought given the startling condition or event which triggered the statement itself? Would we agree that that is the law?
I would agree, that's where I was doing it. It
Yeah.
has to be spontaneous, it can't be upon time of reflection, get a phone call, then tell her what happened.
Okay. You're suggesting that based on what we've heard thus far, that the basis that the state says existed hasn't been shown yet. For instance, and it may be that we just haven't heard that yet, we don't know what the startling event may or may not have been at this juncture. I will tell you that's the case. You don't need to argue that. That's true. Here's what we have heard, I believe, and I'm going to let you proffer through this witness what you believe the testimony, because I haven't let her fully answer that question. So at this time, understanding you have further objections, I'm going to allow you to proffer further testimony to see if that portion of the necessary foundation can be laid. All right?
Yes, Judge, I appreciate
All right.
that.
Go ahead.
Okay, ma'am, at this time, you are allowed to divulge the content of the communication. So, when you did reach Melissa Howard, what was the first thing that was out of her mouth as you were talking to her?
The first thing that she said was, I knew this was going to happen.
Did she elaborate on what that was?
Well, after I asked her and said, you knew what was going to happen.
What did
And
she
she
say?
said, I knew Brian was going to send one of his men over to scare me.
Did she say who Brian Howard sent to scare her?
She said it was Russell.
What was your response to Russell?
I said, is it the Russell that you've told me about before? And she said she wasn't sure. And I said, what? Tell me his name. And she said, David Russell Holbrook. And I want to say she had a junior at that time. She said his full name.
Was there anything else that she relayed to you that Russell told her while he was there?
Well, I asked her, why was he there? What did he do? And things of that nature. Because she was getting to the point where she couldn't talk to me. And she said, you need to let that boy be with his father. You need to let this go. I asked her if he hurt her. I don't know if you want me to go that far. If he had, she wanted to know what to do. And I said, if you feel threatened, you need to call 911 if he's, and I honestly don't know the result of that.
During the course of your conversation with her, these details that she provided, how was her tone of voice, demeanor, all of that as compared to when she first answered the phone?
The more she talked about it, the more upset she became. He was in her house. She told me he came in her house.
Those are my questions, Judge.
I want you to feel free to ask questions you deem to be appropriate at this time. You don't have to, but if you feel you need to, I want to give you that opportunity.
Yeah, maybe. Or how long was this conversation?
It was less than 5 minutes.
And she was calling you her.
No, I called her. Yes.
And she knows she's talking to her. Correct?
Yes.
Okay. And he's asking you, and y'all are discussing what can be done about this. Filing something, getting an order, getting an injunction, or those kind of conversations.
We didn't go into that much detail. My main question was whether or not she had been hurt or she felt like she was going, that he was going to come back. So I said call 911. That was
She
it.
asked you and her attorney what to do. Is that correct?
She wasn't asking for legal advice, if that's what you're asking me. She was scared and she didn't know what to do. And I think I just kind of called at maybe the right moment. I'm not sure.
The contents of what you're discussing happened after you called her. Is that right?
Yes.
She had called your office.
The day before.
The day before. You called her back, and this is the call you're describing?
Yes.
Okay. Go ahead. That helps me to understand. Go ahead.
But you relayed to me. You're her attorney. You're on the phone with her. You relayed to me. She asked me what to do.
Okay.
She's asking her attorney what to do now. Is that right?
She did. What should I do about this?
Right. You were going through, call 911, call the sheriff's department. You're going through those things. Now, we don't know. Obviously she died a couple of days later, so I don't know if she came at you the next Monday at the office.
Are you going to ask a question or provide testimony of your own?
I'm just trying to.
I'll let you ask a question. Feel free to do that.
Is she wanting you to help her do something?
When you say about it, you mean Mr. Holbrook?
This event that you planned for her, was she wanting you to help her do something? Do something in the future?
I can honestly say I took it two ways. What do I do about the fact that this man came in my house? And what do I do about the fact that he's here on behalf of my former husband, Brian?
Did you tell her to make an appointment, to come in, talk about it, get an injunction? Did
We talked on the 5th, the following day. A very brief conversation.
Talking about this night, y'all made an appointment for her to come in on the 5th.
No. Well, I can say I don't remember making an appointment with her. This was not a normal case. I talked to her fairly often, and she would drop by my office fairly often. So she would come by without appointments sometimes.
On the 4th, she's talking to you, asking what to do. Somehow or another, y'all are discussing what she's going to do. Up through the next, if you don't all specifically whether appointment for that call or not. Call.
I don't recall if we made an appointment. No, I do not.
But the plan was for you and her to talk later about it. Okay?
The plan was for her to get safe that night, and there wasn't really a plan beyond that. Because 2 days later is when the exchange was to occur, and I'm almost out of it at that point.
All right? What the court is going to do is this. Given the situation, there's some evidentiary questions that have been raised and some very timely objections made to what we believe to be testimony that this witness would be providing. The way to proceed is to give both sides an opportunity to provide the court case law with respect to the evidentiary foundations required and exceptions, if any, to the hearsay rule to allow that which has been proffered to me with respect to this witness's testimony. Therefore, we're going to stop at this time, and the witness may have to be recalled. Of course, that will be up to the state or the defense if they deem it important to recall this witness. In addition, if there's some evidentiary questions that need to be further developed with this witness's testimony, you'll be able to raise those issues, Mr. Jarvis. All right, sir? Of course, Mr. Warren, I think you're the one that made that request. I think it's an appropriate request. So what we're going to do at this time is you may step down. You're still under subpoena and may be recalled. Now, that being the case, I still feel that the trial is moving along from the standpoint of presentation of evidence in a very efficient manner. Therefore, my intention is to break for the day, to give both sides an opportunity to provide case law to me, which I want on my desk by 8 o'clock in the morning. Fair?
Yes, Your Honor.
You can email it. You can email it to my JA, okay? But I get her here early and I want an opportunity to fully develop, and I think that's fair and it gives both sides an opportunity to do so. Any problem with that procedure? Well, in a brief argument, by the way, if it's more than one page, it's not a brief anymore. I have the ability, you know that, and I say this, but I say it quite seriously. So this isn't my first trip in here. I know exactly the well-framed, and I want to emphasize that, very well-framed positions of both sides. But out of an abundance of caution and fairness, I want to give both sides a full opportunity to provide to me what they believe the state of the law is with this important testimony. All right? Okay. Anything further? I'm going to bring the jurors in and excuse them for the day. All right? Let's bring the jurors in at this time.
Can we approach?
Of course. Yes. All right.
Please rise for the jury.
Ladies and gentlemen, have a seat, but don't get too comfortable. And here's why. When you were taken out, there are some legal matters that have arisen that's going to require some work on my part and the attorney's part outside of your hearing. Now, it may take 45 minutes to an hour. You're not going to have to wait for that. We're going to break for the day. I will tell you this, the trial from my perspective, and this isn't my first one, is moving along in a very expeditious manner. We told you, I think, during jury selection how long it might take. I will tell you that even though we're breaking earlier than anticipated today, that we're moving, I think, more quickly than we had anticipated for your planning purposes. And I think one of our members asked about working this weekend. We will not be. But we'll be back at 9 a.m. tomorrow. But I feel it only right to break for the day so you can get home in a little more reasonable time. You've noticed the cameras. And if you didn't know, you probably have figured it out. This matter is being live streamed, and many people all over our community are watching it live. Therefore, the opportunity for someone to see you and want to talk about the case, including your family members, is there. I trust that will not be a problem, but it is a point of emphasis that you not avail yourself of any information, talk to anyone, and let anyone talk to you about that. I know you haven't forgotten that, but that's a point of emphasis that trial judges are told to make, and so that's enough on that subject. Anything further before we release our jurors for the day? All right. Well, have a pleasant evening. Thank you very much, and we'll see you in the morning. I'm telling you, I like your shirt, right? Is there anything we can take up or need to take up, attorneys, that you can think of before we break for the day? Everyone can have a seat. In fact, you're free to exit. You're free to stay. Whatever the gallery wishes to do is fine. Anything further?
Nothing from the stage, Judge.
I will comment, based on the scenario that we were faced with, counsel, I thought that the approaching and making the objections that were made out of an abundance of caution and wise to do. And I do think it's reasonable, given the circumstances, for us to take the action. And I appreciate very much you stepping forward to make sure if something untoward was to happen, we could prevent it. All right? Not suggesting that it is, but out of an abundance of caution, that's why we're taking the action we're taking. Anything further?
Okay.
There being nothing further, we are adjourned for the day.